Hello dear friends and followers, welcome to Vidhi Vyakyan. Today in this video, let's learn what is a writ and what are the kinds of writ defined under Indian Constitution. Whenever we speak of fundamental rights, one may notice that fundamental rights are the basic rights which are guaranteed by Constitution to the citizens. So there must be a guarantor to fundamental rights, otherwise it may lose its meaning. So the courts are the custodian of fundamental rights in case of infringement of fundamental rights. So Supreme Court of India is regarded as custodian of Indian Constitution. In India, through the issue of writs, the courts protect the fundamental rights of the citizen in case of encroachment. So let's learn what is a writ and what are the types of writ in this video.
By a judicial authority that commands a person or entity to perform a specific act or to cease to perform specific action. Now let's see some of the legal provisions relating to writs. In India, Article 32 of Indian Constitution provides the citizens right to approach Supreme Court in case of infringement of fundamental rights. One can notice that Article 32, which is in Part 3 of Indian Constitution, is itself a fundamental right. And under Article 226 of the Constitution, High Courts are given much wider power to issue writs in case of infringement of fundamental rights as well as for other purposes, that is other legal rights. So, High Courts in India got much wider authority to issue writs. So, this is all about legal provisions relating to writs. Now, let us focus on types of the writs. As per Article 32 and 226 of Indian Constitution, there are 5 types of writs. They are Habeas Corpus, Mandamus, Certiorari, Prohibition, Quo Warranto. So let's understand these writs in much more detail. Number 1. Habeas Corpus. It is a Latin expression which means have the body of. It is a writ issued to bring a person before a court at a stated time and place to decide the legality of his detention or imprisonment. Through this writ, the court commands the state, non-state or inferior court to produce the body of the defendant with a statement to show the cause of detention. To understand this, let's take an example.
As per Article 21 of Indian Constitution, no person shall be deprived of his life or personal liberty according to procedure established by law. So, to detain a person by a state, there must be a procedure which is established by any law. So, consider an example where a person was imprisoned by the police without following procedure established by law or without giving him opportunity to represent in the trial. In such cases, the Supreme Court or High Court can issue suo motu by its own motion, or the application filed by the detained person or his relative can issue habeas corpus writ to determine the legality of the detention of that person. If the court concludes that it was illegally detained by the police, then immediately it can grant the release of such person. In the case of Sunil Batra versus Delhi Administration 1980, the application was made before the Supreme Court of India on maltreatment of the prisoners by detaining authority. The Supreme Court, taking into consideration of this application, issued a writ of habeas corpus against the maltreatment of the prisoners by the detaining authorities.
Government. It cannot be issued against a private individual or a body. The object of mandamus is to ensure the performance of public duty, keeping the public authorities within their jurisdiction. But the person seeking mandamus must have legal right to do so, and authorities should have duty to perform such act under the law. Now let's understand this by taking a case law.
In All India Tea Trading Company versus SDO 1962, the land acquisition officer was refused to pay the interest on compensation amount. The writ of Mandamus was issued against land acquisition officer to reconsider the application for the payment of the compensation.
Then through this writ, the court can quash the order passed by the lower court or tribunal, or it may transfer the case. The object of certiorari writ is to check the legality of the order issued by the lower court or tribunal acts without or excess of jurisdiction or violation of rules of natural justice. Number 4. Prohibition. It means to stop. Prohibition writ is issued by the court to prohibit or restrict the lower court or quasi tribunals or tribunals from doing something beyond their authority. This writ is issued whenever the lower judiciary exceeds its jurisdiction or violates the rules of natural justice or infringement of fundamental rights. The only difference between prohibition and certiorari writ is that prohibition writ is issued whenever the case is pending or during the proceedings, but certiorari writ is issued when the case is heard and ordered by the lower courts. Number 5. Quo Warranto. It means by what authority. Through this writ, the courts calls upon a person holding a public office to show under what authority he holds that office. Its objective is to prevent a person from holding an office which he is not entitled to. By this writ, such person can be removed from his office, but this writ cannot be issued with respect to a private office. This writ can be used when the public office is illegally assumed by the private individual or the person holding the office is not qualified to hold that office under the constitution or any other law. Let's see a case law.
In the case of Jamalpur Arya Samaj Sabha versus D. Ramu 1954, the application was made before the High Court to issue the writ of Quo Warranto against the working committee of Bihar Arya Samaj Sabha, which was a private body. So the High Court refused to issue Quo Warranto because it was a private body. This is all about writs and types of writs defined under Indian Constitution. I hope this video was useful for you. For more updates, please subscribe to Vidhi Vyakyan channel, like, share and comment in the section below, and follow us on Facebook page Vidhi Vyakyan. Thank you.